Good morning.
Morning.
All right, good morning. Good morning, everyone. We're going to resume the Municipal Officers Electoral Board of the City of Evanston. This meeting started on Monday of this week, then was recessed to yesterday, Thursday, and now to today. Our hope is that today we'll wrap up this electoral board meeting. We have a couple items on the agenda today, but before I do that, I just want to do a quick roll so that we confirm we have all of our board members. Alderman Rainey, are you here?
Here.
Clerk Reed, are you here?
Here.
All right, this is Mayor Haggerty, and I am here. So we have everyone here to resume this meeting. We have one case today to hear, and then we need to just approve the written decisions of the board that were made yesterday. And I'll have Kelly take us through those. But what I'd first like to do today, because of news I just learned this morning, is I would like to move item number 9 on our agenda, which is case number 20-MOEB-EV-07, which is Evie Krause Russell versus Eleanor Revelle, who's a candidate or has submitted petitions to be a candidate for the 7th Ward here in Evanston. I understand, Ms. Gandersky, that there has been a motion that was made last night by the objectors to dismiss their objection. Is that correct?
I just received it this morning. Mr. Finko, are you here? Could you turn your camera on, please?
Good morning. Andrew Finko for the objector, Evie Krause Russell.
Can you please spell your name for the court reporter and your client's name?
Sure. Andrew, A-N-D-R-E-W, Finko, F-I-N-K-O. And the objector is Evie, Y-V-I, Krause, K-R-A-U-S, Russell, R-U-S-S-E-L-L.
Thank you. And do we have someone here for Eleanor Revelle?
On behalf of the candidate, this is Michael, M-I-C-H-A-E-L, Kreloff, K-R-E-L-O-F-F. I am her attorney, and I believe Ms. Revelle is also here.
Okay, and can you please spell your client's name as well?
Eleanor, E-L-E-A-N-O-R, Revelle, R-E-V-E-L-L-E.
Okay, very good. I received this morning from Counsel Finko a motion to withdraw the objection. Is that correct, Counsel?
Yes, that's correct. The objector saw initially that there were a number of candidates that were objected to based on the paperwork not being stapled together. And then noticed that candidate Revelle, or Alderwoman Revelle, who had previously submitted nomination papers and presumed to know how to do this process, similarly did not staple her paperwork into one bundle. So the objector's motive was to make sure that ballot access was provided to all candidates even-handedly. The objection was filed based upon the stapling issue with Alderman Revelle's paperwork, and then based on the objections that were presented yesterday and the rulings of this board to promote ballot access, the objector in this case similarly would request that, presumes that the same ballot access would be afforded, and based on that, those rulings and decisions, we will withdraw the objection to candidate Revelle. And we'll leave the question of what happened to the oral history of Evanston as told by political followers, and we'll see what happens down the road.
Okay. Mr. Kreloff, do you have any response to the motion to withdraw?
Yes, I do, Ms. Gandersky. We object to the language in this motion. Let's recognize there's a political campaign going on. And this motion is an attempt to politicize the process here and to simply be an attack on a candidate who we believe under the law has followed statute and has followed proper procedure. we obviously have no objection to this, to the objector's withdrawal of her petition to object to the candidacy. I'm sorry to the court reporter, these words may be getting confusing. If Mr. Finko wants to withdraw his case, he's certainly quite able to do that. But the contents of his motion are an attempt to mislead what the actual facts are. We have taken the position in all of our memoranda that what Ms. Revelle did was entirely proper, admittedly not the way these petition filings are often filed, where everything is attached together, but that she did file adequately under the law, and that under the law there was substantial compliance and no violations. This motion is to set up an attack, and we do not believe that the board should simply dismiss based on this motion. If the board wants to dismiss the case, please do so. We don't think it ever should have been filed.
Mr. Finko, any very brief response to that?
Well, we have different interpretations of the facts in the law, and I'll leave that to a future electoral board or a future appellate court to decide. We're just withdrawing the objection. The prefatory language is restating the objection that was lodged, and we'll leave that for another day.
And that's not accurate, if I may. May I respond?
Sure.
That's not accurate, that it's simply restating. It's saying that she knew or should have known. It's saying it's in two packets. You now have the papers before you. You now have the case law before you. You know it's not accurate to say that it's two documents. It's not accurate to say that she knew or should have known. That's simply an attack. And I would ask that this board simply enter an order dismissing the objection. I don't care if you don't list any reasons.
All right. Thank you, gentlemen, for the argument. Mr. Finko, I do have a question. And again, for the record, I am not the judge for this board. I'm not the judge or jury. I'm here simply to advise the board. And to do so, I have a few questions for you. My understanding is the objector's petition was based upon an allegation that candidate Revelle did not staple her statement of candidacy to the nominating papers. Is that correct?
That's my understanding, yes.
Okay, but I did not recall reading, and maybe my memory is short based upon all the cases that we heard this week. I did not recall reading whether or not any of her papers were stapled together, or I believed that it was just your allegation or Ms. Russell's allegation that the statement of candidacy was separated from the nominating papers, which was the crux of your objection. Is that correct?
Yes, let me, I'm going to pull up the paperwork. My understanding was that, let me take a look, was that the.
Your motion to withdraw is different, if that's the case. I do want to.
Well, the motion to withdraw is to withdraw the entire objection
Right.
in its entirety.
But the statements in the motion to withdraw are, to me, differ from those of the objection.
Well, the objection stated that she submitted two groups of nomination papers. That in paragraph 2, the candidate Revelle circulated petitions and submitted petitions bound together, but without a statement of candidacy attached.
Okay.
That separately. So my understanding was they were bound.
But the original objection was that the statement of candidacy was not attached to the nominating papers.
Right, and the argument that I was presenting was that, let me see, that there was a separate group. And so there's some case law that says you can't submit two sets of nomination papers. It has to be one set. And, as Mr. Kreloff noted, that typically candidates submit one group that is bound with either staples or these little ACCO binder clips that have two pieces of metal that lock together.
Yeah, I don't want to get into the merits of it. I'm just simply asking what was the nature of your objection versus what the nature of the motion to withdraw is.
The nature of the objection is that there were two groups of documents filed for this candidate. Mm-hmm. And taken separately, the electoral board would then have to decide which group do we accept and which group do we reject. One group of papers is bound without a statement of candidacy. The other group of papers contains no signature petitions. That was the argument and in the objection. Now, at this point, I think that's all moot simply because the objector is requesting the withdrawal of the entire objection. And so we don't need to reach a decision on any of those issues.
All right, thank you very much for your response. I'm going to recommend to the board that you accept the motion to withdraw without rendering any findings, since it is the objector's motion to withdraw this objection. And there hasn't been any evidence heard on the merits of this case. All of the pleadings are on file and will remain on file on the city's electoral board website. So to that end, I don't think that the board needs to consider the merits of this case. I think the board may simply just accept the withdrawal, the motion to withdraw without rendering any findings. And we can just effectuate an order reflecting that.
Thank you. May I just add, I would like, if you would, that the order reflecting that also reflects that the candidate denies the allegations in the motion.
I don't see an issue with that, but that's up to the board.
I'll move to accept the motion to withdraw.
Period. I don't accept the part about adding the extra statement.
Sure.
Okay, well,
I'm with Alderman Rainey.
I'm confused. I'm confused by your motion. Clerk Reed.
I'm making a motion to accept the objector's withdrawal of their objection.
Second.
All right, is it open for discussion? So just so we're clear, accepting their motion of withdrawal, but not adding to that motion that we are rendering as a board no findings in this case means that Mr. Kreloff's argument just now is being ignored by the board.
Yeah.
And his argument, as I understand it, is that this motion to dismiss, he disagrees with the statements that are made in there. His candidate does. And so I'd rather see us move a motion to accept the withdrawal, but the board is rendering no findings.
Right, because we have no case. We have
Yeah,
no.
But that's not the motion that was just moved and seconded.
Yeah, that is.
Yes, it is. We're accepting Attorney Finko's withdrawal of the case.
That's what
We have no case.
That's what I understood the motion to be. The question was whether or not the order should contain a line stating that candidate Ravel disagrees with the allegation in the motion to withdraw.
That's not included in Clerk Reed's motion.
That's correct.
Yes, I agree. Otherwise, I wouldn't second it. Why
All right,
is it so complicated? There is an objector withdrawing her case. We're agreeing to accept the withdrawal, period. Boom.
I
Moving
call
on.
the question.
Second.
All right,
We
so
can
let
agree
me do the roll. Let me do the roll. All right, Alderman Rainey,
Am
you're Alderman Rainey. On
I
this motion.
voting on calling the question, or am I voting?
I guess we're voting on calling the question. Fine. So we don't have any more discussion. I think it's lousy that Clerk Reed is shutting down discussion, honestly, when we have been, and I have been very patient over the last week, allowing you to carry on with conversation, and you're shutting it down right now. But that's what he moved. So you're an aye, Clerk Reed.
I'll vote no, just so you can continue conversation, Steve.
Okay.
I vote no.
Okay. Okay.
Okay. Thank you. I would like clarification on the point that if we are just moving a motion to accept the withdrawal, are we, and I guess this is for you, Ms. Gandersky, are we accepting the written statement of the withdrawal by Evie Russell?
The council, sorry, the board is accepting the withdrawal of the entire case. The order does not have to reflect the allegations that are set forth in the motion to withdraw. Mr. Kreloff has asked that the order enter a line stating that Alderman Ravel refutes the allegations in the motion. I don't think we need to put anything in the order other than the motion to withdraw is accepted and there is no objection before the board, period.
I agree that we shouldn't put anything about Alderman Ravel and her opinion of it. But I'm trying to understand is the motion that's on the floor right now, Ms. Gandersky, what you wanted us to move, because your specific language was a motion to accept the withdrawal and render no findings.
That is correct. That's the motion.
That's what you said.
That's what I believe.
That is the motion?
Yes. Yes.
Okay, if that's the motion, I'm supportive of that motion.
Thank you.
Okay, well, thank you for giving me some more time, Clerk Reed. I appreciate your generosity. We're going to do the roll now. Alderman Rainey.
Aye.
Clerk Reed.
Aye.
I'm an aye. Okay, the motion to withdraw has been accepted. Thank you, Mr. Finko, and thank you, Evie Russell, for putting forward that motion.
I'd add
Alderman
because
Rainey. Alderman Rainey.
And would it be appropriate to make a comment about the withdrawal?
I don't know.
I just want to say just one thing about the attorney's comments. I found them offensive, just to say that. But I'm accepting the withdrawal.
Okay, all right. So we're now going to move on. So that case now has been handled. So we have heard all the cases that were before the board. We're now going to discuss the open written decisions that need to be filed in these cases. So Ms. Gandersky, if you want to take us through what we need to review and accept.
Well, in order of a hearing yesterday, we heard a consolidated matter 20-MOEB-EV-03, and we consolidated that with -06. That was Mile Davis, Catherine Whitcomb et al. Versus Eric Young, and we have prepared a written order. Ms. Ruggie, can you please share your screen? And make sure that it's the font size is able to be read. You know, if we can zoom in this time.
I will do my best.
Okay, thanks. Okay, you can scroll down a bit. This is just the caption.
If the other two board members are good, I'm good. You can scroll down. You can go scroll down unless Alderman Rainey or Clerk Reed need more time. We're good.
No.
How about let's just show the findings. If you can scroll down so we can see more of the findings. Oh, can we go back up to findings just to look at the three findings real quick?
Yeah, I was going to say there's no finding. I think it would be appropriate to add here that, we found that Mr. Young had, placed his petitions in a manila folder. I mean, I think that's, I don't think we have to say it.
Yeah.
It wasn't a manila. Oh, okay. I'm sorry.
Was an envelope.
Yeah, I'm sorry.
Okay, why don't you scroll down to the next section, Alex?
Would it be appropriate, the clerk's office did not issue a letter of apparent conformity or non-conformity?
I would just say, we haven't said that on any of the decisions that we've issued to date, and we're probably best just
Though this is a little different. The other issues wouldn't.
remain silent on. I mean, there's lots of things. Go on.
Oh, I'm sorry. This issue is a little different because the other, or at least the cases that we've decided thus far weren't necessarily apparent conformity. Maybe Ms. Carrillo's was. I wasn't involved in that one, but this one is an issue that other jurisdictions may look at it and say, it wasn't in apparent conformity, and just administratively remove the petitions for not being potentially bound. So I think it might be important to note that this jurisdiction did not do that, which may even support the case of why we're putting them on the ballot. The fact that the clerk's office who accepted them did not say that they were not in apparent conformity, which is allowed under the statute. And in fact, most other jurisdictions would do.
What do you think, Kelly, to that suggestion?
I don't recall there being a finding by the board. If the clerk feels the need to do that based upon his powers as clerk, then that's up to the clerk to do that. But I think for purposes of the finding on this particular objection, I don't recall any of that being made part of the record.
Yeah, it was discussed during the case. I asked it to Attorney Dale yesterday, but I think it's important because if the clerk has the ability to administratively remove this person for non-conformity, and the clerk and I did not do that, I think that supports the fact that, this gentleman's on the ballot. We had the ability to just administratively remove him and did not.
So you're asking for, in line in the order that says the clerk's office will issue a letter of apparent conformity to this candidate?
No, that we did not issue a letter of non-conformity. That typically, you don't issue letters of apparent conformity. If someone isn't in apparent conformity, you issue a letter of non-conformity, and we did not issue a letter of non-conformity.
I'm okay with that going into the order. If you want to put that under a factual
Finding. Yeah.
Alderman Rainey, are you okay with that?
Yes, I am.
I am as well.
Okay.
Does that look good to you, Clerk Reed?
Yes.
Okay.
Oh, I'm sorry. And also the
Let's go back
factual
to that
findings.
section
Did we
where
not
we're reading.
Did we not also find that the deputy clerk gave Mr. Young information stating that he could file his petitions as is?
I know that was a factual dispute of some sort. I don't recall the board saying that that was a finding. that they found that to be the case. I know that was testimony on both sides, but
I think Deputy Clerk Gomez confirmed, in fact, I know Deputy Clerk Gomez confirmed that he told candidate Young that he could turn in his petitions as is.
right, but I don't, was that a reason that the board is issuing this ruling? That's the question.
That's certainly a reason that I'm issuing the ruling. I mean, I think the fact that an employee who folks might think has the authority to, make that kind of determination, that's to me the number one reason why I'm voting for this. To me, the binding of the city or the estoppel doctrine or whatever you want to call it is what I think protects Mr. Young from not following.
I would need Mayor Haggerty and Alderman Rainey to agree to that as a finding by the entire board.
I would agree to that. That is why, that was a big part of my decision making, was that the deputy clerk said, you could go ahead and hand these to me in that manila envelope.
In both cases, the implication was clearly there. Yeah.
Yeah.
Okay, so Alex, you had a line stating that the board finds that the deputy city clerk informed candidate Young that he could turn in his nominating papers, quote, as is. I think it should be period and then quotes, sorry.
I actually think in this instance, it would be quotes and then the period, because it's ending the entire sentence, not the quotes as a.
And we did discuss also that the mere acceptance by the clerk's office did not necessarily make the petitions valid, But
does the board want that as a finding?
I think that's a
Well,
given under the law. I mean,
it is, and not necessarily understood by all of the candidates to be.
Well, I think we've outlined this, and so we can scroll down to the applicable law.
Yeah.
Whenever
Are you okay if we
folks are
scroll
ready.
down? All right, go ahead, Alex, and scroll some more.
I have concerns. So the standard of Ms. Gandersky, the standard of review for the circuit court is a pretty tough standard, correct? In that, or can you describe the standard of review?
The standard of review and administrative review would be manifest weight of the evidence, most likely, which is a very difficult standard to meet. It's basically the decision of the board gets overturned if there was no reason at all in the record for the board to rule the way that it did.
Yes. Okay. And so with that, I want to make sure that we word this so we are making sure that we have a valid reason. So we are meeting at least that standard, because I do know the courts tend to side with a board as long as we meet the standard that you just outlined. Here it says substantial compliance. I really think the standard for binding isn't substantial. I think it's mandatory, and I think that in part, again, my determination was that he met the, not substantially, but he met maybe the compliance by the fact that he put it in a binder. I mean, not in a binder, in a folder, in a envelope. And that there's also, well, we can scroll down and see what else is listed.
This substantial compliance is the standard for this particular issue, and the case law is pretty clear about that. So I'm gonna have to say
Okay.
respectfully that that is the standard, and that's what needs to go in the order. Alex, can you scroll down so that we can read the rest of that Mertz? Thank you. So the Mertz case is put in because that's the case that essentially talks about, it doesn't really call it estoppel, but it talks about that detrimental reliance, where a candidate relied upon the clerk's office. The clerk's office was an error.
All right, can you scroll down if the other two are ready? Let's to decision, electoral board.
I don't know that I like, the board also determined that the integrity of the nominating papers remained even though, I mean, that's kind of that is judgmental. Young submitted them in a manila envelope to the clerk's office. Even though.
Would you prefer that we
It
just?
was likely they wouldn't have been, it wouldn't have, the integrity would have been, I don't know, it's a very judgmental sentence.
I think
There's a
striking that
likelihood
sentence
the
makes sense.
integrity would not have been secured in a manila envelope.
Well, I recall Mayor Haggerty stating as part of the reason for his vote, his finding is that there was no allegation that handing the nominating papers to the clerk's office in this way violated the integrity of those nominating papers.
Right.
Yeah, I think that, oh, sorry.
So, we can rephrase it, I suppose, but we could say the board also determined that the integrity of the nominating papers was not called into question upon submission.
Yes, I like that better.
Yeah.
To the city clerk's office by candidate Young. Thank you. Alex, I'm sorry, change candidate Young to respondent Young, just to be consistent.
Honestly, I would drop that and just say to the clerk's office, period. I mean, I think it's determined the integrity of the nominating papers was not called into question.
Yeah.
We know they were submitted by him. I think it gets confusing. If we add by, it's like, okay, well, the integrity wasn't called into question by Eric Young. I mean, the fact of the matter is both attorneys said, there's no claim of fraud. The deputy city clerk reiterated nothing had been added or subtracted from these papers. They had been numbered. So I think adding the by Eric Young just sort of makes it a little confusing. So I just leave it the way it is. And I still don't think it's a perfect sentence, but I know we have other cases to get to, and
Well,
you could be very specific. You could say the board also confirmed with, all parties and deputy clerk that know that all paperwork had been numbered and that there were no additions or subtractions to this file.
I think we didn't.
Specifics.
Well, didn't we put that in the factual findings? Essentially, we said that.
The factual findings.
Yeah, then leave the sentence the way it is and it's fine.
Yeah.
All right, are we good with this order?
Yes, I am.
Yeah.
Thank you. So Alex, can you send that off to have Mayor Haggerty, Clerk Reed, and Alderman Rainey e-sign?
Yes, I'll do that right now.
All right, Alex, whenever you're ready, I think the next one, should we call the Jefferson versus Mendoza case?
Yes.
All right, Alex, let me know when you're ready.
Yeah, just give me 1 second.
Maybe we can just power through all of them and then sign them all at the end. Take maybe a 5-minute recess to sign everything.
I agree. She's just getting them ready for e-signature. It takes a few minutes to set that up, so that's fine. Okay, so the next case, Mayor, do you want to call it, or do you want me to call it?
You can go ahead and call it for us.
Next on the docket, 20-MOED-EV-02 Willie L. Jefferson versus Rebecca Mendoza. This is the office of the Fifth Ward. We have prepared another order. This is pretty similar to the Mr. Young case. So Alex, can you scroll down? I would start it with procedural history. There you go. Okay, let's go to factual findings.
I apologize. Can you scroll up a bit? Maybe I'm just, okay, never mind.
Yeah, that's just the heading.
If you press the arrow key, Alex,
Move it over.
there's up in the right-hand corner next to the pencil icon, there's an arrow next to it. Yeah, if you click that, it just adds a little bit more.
I think we have a typo there. It should be placed, the photographs.
I'd almost say uploaded, but.
I agree. I'd say uploaded too.
Where would you say uploaded instead of placed?
Yeah.
Oh.
I don't know if we, as far as a factual finding, I don't think it's undisputed. Well, one, do we have to include that the deputy clerk testified that he did not tell the candidate that it was legally sufficient? I mean, I get that he didn't specifically say that.
Well, I was taking notes during the testimony. This one was a little bit different because Ms. Mendoza wasn't represented by counsel and she actually called a witness. So I think it's,
Okay.
I thought it was fair to put in, all of the testimony that was had.
I do disagree that, I don't think it's, I dispute that the deputy clerk was instructed by the city clerk not to provide a stapler or paper clips.
You dispute that he testified, though, that's what he.
Yeah. Well, we can move on to applicable law if everyone else is.
This is pretty much the same as the other case because it involves the way that the petitions were turned in. So this is the same, we use the same standard in the same code section.
Did we make any changes to the last one we want to include in this one?
Alex, can you scroll down, please?
I thought in the last one we added that the clerk did not issue, or maybe we did that.
Oh, yeah. And for the findings, yeah, we should add that as well, that the clerk didn't issue a letter of nonconformity.
Alex, go back up to factual findings and then just add the last sentence. There you go.
Should it be a separate paragraph? Just curious.
Okay, then the applicable law is the same. Order. And then this is we can adjust the language here if you want to.
The board determined the integrity, that line.
I don't like that last sentence, Alex. Can you change it to the one we had in the previous order?
I'll enter the exact language from the other order after we're done and I can pull it up. That way it's the same.
All right, any further comments or questions on this order? All right.
No.
All right, then seeing none, Alex will go ahead and just make sure she incorporates similar language that we did in the prior order. All right, Kelly, do we have others?
Yes, we have 20-MOEB-EV-04 Allison Harned versus Jane Grover, Office of the City Clerk. Whenever you're ready, go ahead and share that one. As you might recall, this was a motion made by Jane Grover to withdraw her motion to dismiss. Alex, can you do that thing with the arrow in the right corner? So it's, yeah, there you go. Okay. You can scroll.
Okay, I'm sorry. I did want to get the first paragraph there just to. Okay. Are we able to scroll down a bit? Um, well, huh. I think in this case, if we're issuing a decision here, I think the factual finding, if I recall, I know the candidate withdrew their motion to dismiss, but if I recall within it, the candidate did, it seems as though the candidate acknowledged that they had 905 valid signatures. And, you know, for issuing an order, so I think either we issue an order that says that the board found based on the candidate's testimony that she had 905 valid signatures, or similar to the Revell case, we just don't issue a decision. Or we issue a decision similar to the Revell case.
I think, Alex, strike the word decision. It just is the order of the electoral board.
Yeah.
And I also don't think we're ordering that the candidate's name not appear on the ballot unless we're having a factual finding that she did not submit the requisite number of signatures, because we have nothing. What could happen here is this would almost seem as though, you know, if someone were to appeal this potentially, what is the board's decision that the candidate's name isn't appearing on the ballot necessarily based on? Withdrawing a motion to this, maybe Ms. Ganderski, you can explain
Wait,
this.
the problem, Clerk Reed, is if we say that and she decides to be a write-in candidate, we have an order here that her name not be on the ballot.
Oh, her name can still, I mean, as a write-in candidate, her name wouldn't be on the ballot.
But I'm just saying, it says the candidate cannot be on. Can't we just say that she's withdrawn her
I think we should,
petition?
I think the candidate has to actually submit. In my experience, maybe Kelly, you can, if you've looked into this, in my experience, when boards have issued this kind of letter, the candidate has actually submitted their official statement, their official withdrawal form.
She do
And
that?
you bring that to the hearing. You look, I've issued a withdrawal, and then that's our finding. Our finding is that the
That's
candidate
only
has
after her petitions have been filed and accepted.
Yeah, what I'm saying is that the finding here should be that the candidate has duly submitted a motion, a withdrawal of their candidacy. There's a form to withdraw your candidacy, and so that should be our finding, that the candidate has withdrawn.
She hasn't done that. So the more that I think about it, we could probably get rid of paragraph 3. Respondent Jane Grover's motion to dismiss is withdrawn by respondent. Petitioner objector Allison Harned's objection to the respondent Jane Grover's nominating petition is granted, and just leave it at that.
But
It's like she was never a candidate.
Well, but I voted against this because I think procedurally we might be making I'm concerned procedurally here, and if we're finding that the candidate is to be removed, we're saying that they're removed from the ballot based on what? We did no records examination. We, just simply the candidate, Ms. Grover, withdrew her motion
Conceded the objection, so the objection sustained. So
then we should have a factual finding that she conceded that she does not have, that should be in the factual finding. We're essentially saying that she concedes that the objectors were correct and that she, had 500 or whatever signatures that were invalid, and thereby she's below the minimum signature requirement. Or we say that she admitted that she had 900, or that she, perceived that she had 905 valid signatures, and thereby that's our decision. It's below the 922 minimum. Just something that backs up why we are.
Can I just jump in here really quickly? So I
Sure.
don't recall her saying numbers. I recall her saying we didn't quite get there. That was the quote that I remember her saying with the signature requirement. If this were to somehow get appealed to the circuit court, along with this order, also goes with it the entire transcript of all the proceedings for a judge to read exactly what was said word for word and all the findings that were made. So while this order is important, the transcript is also very important because it discusses word for word what was actually said, which is why we have a court reporter, because none of us exactly recall every detail. So the way that I understand this, there's an objection on file. The candidate was fighting the objection. She decided not to. She conceded that the objection should be sustained. So
then our finding should be that, we should have a finding that says that it's presumed that the objection is valid, essentially saying that whatever number of signatures they said that she did not have. And if I can just very quickly, in her motion in candidate Grover's motion to dismiss, she did concede there a number of 905 signatures.
That's all part of the record. So I don't know that we need to put every single detail in the order. We just need to determine what's happening with this candidate. She's not going on the ballot, correct? Because the objection sustained. So she's not going on the ballot. It's the same as Shelley Carrillo, who also didn't get on the ballot. She's not going on the ballot. So my personal opinion is, my legal opinion is that 1, 2, and maybe we can leave paragraph 3 that she's not going on the ballot. If she gets on the ballot some other way, then that's fine. But she's not getting on the ballot as a candidate. Her name will not appear. Her name will not appear on the ballot, like the other candidates' names will appear. And if this were to get appealed somehow, there's an entire transcript and there's pleadings of the proceedings reflecting every allegation, every fact, every concession, everything that was said. This is simply just to dispose of this matter. That's what the purpose of the order is.
Alderman Rainey.
So is the board okay with this?
Alderman Rainey.
Could I ask about one fact in this case? What was the basis for, what was the total number of votes cast for city clerk in that election?
I think it was a little over 16,000.
When I looked at the the county clerk's office, it was 14,000 something.
You're correct. 14,759 is what I have in one of the pleadings.
So you know what 5% of that is?
5% of that is 738 signatures. But the issue in this case was whether this should have been 5% of the tally of the entire votes for the clerk's office or citywide. That was the issue.
But why was it different for the clerk's office than everybody else?
It was not different.
So if it's 5% for the clerk's office, the minimum number of votes was 700 and something, not 900 and something.
Section 10.3 provides that nominations of independent candidates and nonpartisan candidates are under the same rules as independent candidates as far as the election code is concerned.
That's right.
For public office within any district or political subdivision less than the state may be made by nomination papers signed in the aggregate for each candidate by qualified voters of such district or political subdivision equaling not less than 5%, nor more than 8%, or 50 more than the minimum, whichever is greater, of the number of persons who voted, and here's the key part, at the next preceding regular election in such district or subdivision. So it's not how many folks voted for the particular office, but how many folks voted in that particular subdivision or district. So the
And
numbers
what
were
was that?
calculated.
What was that number? 18,000 something?
Number of folks who voted?
Yeah.
Oh, off the top
Like-
of my head, I don't remember. Whatever, 922 is 5% of the number, so.
All right, are we okay with this order then as written?
I'm okay with this order. If the other two board members are.
I'm not okay with it, but I mean, we already voted the way we're voting, so.
What is your objection to the order, Clerk?
I just really, my experience tells me it's really important that we include some factual reason for why we made this decision. And, we should have some factual finding that either candidate Grover acknowledged that she did not have, the minimum number of signatures, that she didn't meet the minimum requirement, or, we didn't do a records examination. I just don't see within the four corners of our board decision here how we arrive at, the fact that that Jane Grover will not appear on the ballot, given there was no records examination.
She's,
I just look at it that we accepted Jane Grover's motion to dismiss. I mean, Jane Grover, presumably either herself or with her attorneys looked at all the facts, looked at the objection, and, made a conclusion that she is going to withdraw her motion to dismiss. Therefore, not arguing the case, we sustain the objection. I mean, we're not an investigative authority.
Right. So, right, we're not an investigative authority. And what happened is that the county board or the county clerk's office would look through the petition signatures and, based on the objections, to determine whether they were sustained or not. We just haven't done that step. And, where we are based on, the candidate Jane Grover withdrawing her motion to dismiss does not automatically mean that the board would look at, if this were a normal situation, the board wouldn't just take Objector Harned's objection at face value and say, of course, to your 500 signatures. There should be some finding that either that Jane Grover, stated on the record that, no, I did not meet the minimum signature requirement of, whatever it is, 922 or 922. I didn't meet the minimum signature requirement. I had 905 signatures, as she said in her motion to dismiss. I think there should be some factual finding of why we arrived to this decision, because otherwise we're essentially just removing a candidate from the ballot. I know this is her wish as well, based on, or she should file the proper document, her motion to withdraw, her withdrawal of her candidacy. It's a document that she files with the clerk's office. And the finding should be the candidate withdrew their nomination petitions, and thereby that's the board's finding the issue is moot because they've duly filed a withdrawal. This is really based on, nothing, essentially. There's no facts that we find here. There's no factual finding of anything.
The facts that the board found was that Jane Grover withdrew her motion to dismiss and is not contesting. So that's the fact. There was no hearing, there was no investigation, there were no other facts. There was pleadings that were submitted that will all be part of the record, but there was no determination made on that. So essentially,
maybe that should be the fact. Just that we should have just a fact that says that Jane Grover withdrew her motion to dismiss and conceded to the objectors.
I would say this, how about under factual findings, the board made no findings of fact as to the merits of the underlying objection. How about that?
Well, then why would we remove the candidate from the ballot?
Because she is asking to be withdrawn.
Yeah, but that's not how the law says. If a candidate wants to, you can't just say, I want my name removed. If a candidate came to my office today and said, hey, I'd like my name removed from the ballot, I couldn't just remove their name. They'd have to file an official document.
Well, that's because they would have been already approved. There was no objection to them. There's been an objection and now it's been withdrawn. She's not on the ballot.
But the board voted by a 2-to-1 vote to uphold the objection. So if the objection is upheld, the candidate comes off the ballot.
I mean, it's fine. We can move forward. I voted no based on that. I have my reservations about the document not being complete.
And right, and all that's part of the record as well. So all that's in the transcripts. All right, so can we move forward on this one then?
I'm okay.
Okay, thank you. All right, last but not
Alderman Rainey, are you
Yes,
okay?
I vote to accept it.
great, thank you.
Okay.
Okay, next matter is 20-MOEB-EV-07. This is Kraus Russell versus Ravel. Alex, can you scroll down?
I have a question about this. What if the board voted to reject this objector's withdrawal?
Well, I suppose then it would have mattered what the respondent had to say about that, because the respondent agreed to have the objection withdrawn. So if the respondent didn't agree to have the objection withdrawn, then we could have proceeded forward on the merits.
I thought that was maybe where they wanted to go, actually. Here, I actually thought that's where they want to go, to hear the case, to actually get the findings documented by the board and
Well,
everything.
that could have gone either way, you know?
I know, it's a risk for them, honestly. Yeah.
We didn't issue any findings here or suggest any, because there really weren't any.
Ms. Gandersky, if in this case, the objector hadn't withdrawn their petition and the candidate here decided to withdraw their motion to dismiss, we would just move forward with the proceedings, correct?
That's right. The board okay with this?
Yes.
I'm okay.
Move to accept the objector's withdrawal.
I think we already did that.
We did.
We're good.
Are we accepting the order? If we are, then we can get these. sent
Yes, go ahead, package them all up, send them to the three of us. We can sign them. Are there any other ones, or does that cover all the cases, Kelly?
I believe that covers everything. Alex, is that right?
Yes, that is correct. I'll send these for signature now. If we can take a brief recess, get these signed, and I think we're done.
This is what I'd like.
Public comment.
Thank you. This is what I'd like to do is we do have public comment. I know we've got Larry Donahue who had signed up for it. Luke Stowe, do we have any additional people that have signed up for public comment?
Let me check.
And so let's just go into to public comment. As I mentioned yesterday, the court reporter does not describe public comment in these proceedings. So give me 1 second, Larry, and let's just see what the
Sure.
list is for public comment.
Looks like that's the only speaker, Mayor.
All right, thank you, Luke. Well, welcome, Larry Donahue. You have the floor.
Okay, thank you. Good morning. My name is Larry Downey. I live in the 3rd Ward, and I've been an Evanston resident for 35 years, having lived in the 5th, 6th, 7th, and 3rd Ward over the years. I listened to the conversations yesterday morning, and I'm really disappointed in the way my city handled the challenges to several of the candidates seeking elective office. And what I heard were some technical and legalistic objections to the candidates' applications. I heard no objections based on a candidate's lack of skills, experience, character, or general unfitness for office. And I was pleased to see that 2 of the challenges were overruled yesterday, Eric Young's and Rebecca Mendoza, and that the challenge to Eleanor Ravel's candidacy, someone who I admire greatly, was withdrawn. But I'm concerned about the decision in the case of Shelley Carrillo and the way that Ms. Carrillo's candidacy was treated. And by the way, I've never met Ms. Carrillo. It was good, and then 2 of the decisions, the legalistic objections, were overruled by the board. But I think the board should have seen through the very minor technical flaw and the legalistic objections in Ms. Carrillo's case and allow her to remain on the ballot. It's clear that those who had legal representation yesterday had a clear advantage in the discussions. It's an uneven playing field for those who don't have such representation. There seems to be almost an unwritten requirement to have a lawyer. Going forward, perhaps the city could maintain a list of pro bono lawyers familiar with Illinois election law who could assist individuals who do not know any lawyers with this kind of specialized experience. Not everyone knows or can afford a lawyer with this specialty. That's it. Thank you all.
Thank you, Larry. All right, that concludes public comment. We have no further people that have signed up for that. We are going to just do a little break here while Alex Ruggie does the work she needs to do. Alex or Kelly, if you just want to tell us how much time do you want us to sort of break? Because once we do that, all 3 of us will sign these documents. Our attorney will provide them to the different parties, and then we will adjourn this meeting.
Can we come back at 10:30?
10:30. Okay, so we're going to keep this live right now, but I'm going to go off camera and mute just to take care of a few other things. And at 10:30, Kelly, just call us. We'll be near our computers, and we'll all turn the screens back on.
Great. Thank you, everybody.
Thank you. All right. Hello, Kelly. My understanding is all the electronic documents have been sent to the board members. I've signed off on all of them. And I believe Alderman Rainey and Clerk Reed are doing that right now. So once you have completed signing off on those, Kelly Gandersky, our board attorney, will let us all know, and then we'll come back and we will adjourn this meeting. Or we will come back. Ms. Gandersky will provide these documents to all of the different parties, explain next steps if anyone wants to appeal, and then we will adjourn this meeting.
I'll just ask that Alderman Rainey and Clerk Reed, when you're done signing, just come back on and let us know, and then we can continue on.
And then let me know, Kelly. I'm just going to take care of something on my computer right next to me.
I believe all of the orders are signed by everyone.
Yep, looks like I'm getting them all back to me now. Okay, all orders have been signed. So whenever Mayor Haggerty is back, we can continue forward. There he is.
All right. Ms. Gandersky, why don't you let us know the procedure in terms of distributing these orders to the different parties and what next steps are available to them?
Sure. So the law department will email out orders as indicated yesterday to those who are present. And we will also make sure that we send them out via mail as well in hard copy. Next steps would be parties have 5 days to file their administrative review action in the Circuit Court of Cook County to file their administrative review if they so choose to do.
Okay, thank you. All right, I'm going to ask if there is a motion to adjourn.
I just want to make one comment, and I want to say to Ms. Gandersky, while we had a number of maybe legal disagreements, you did a fantastic job, I would say, of running the procedures here and making sure that we created for the court reporter a clean record and made sure folks were, you weren't biased in any way. So I just want to say a really good job at running the hearings today or over the last week.
Thank you, Clerk Reed. It was a pleasure working with both boards.
All right, so is there a motion to adjourn?
So moved.
Is there a second?
Second.
All right. We'll do a roll call on adjournment, and this is adjournment of the Municipal Officers Electoral Board of the City of Evanston. Thank you for everyone's good work in going through and completing 6 objections that were initially filed. So I vote aye for adjourning. Alderman Rainey?
Aye.
Clerk Reed?
Aye.
All right. This meeting is adjourned. Thank you, everyone. Have a nice day and nice weekend.
Thank you, everybody. Have a safe weekend.
Thank you, Kelly. Thank you, Alex.
Ms. Allman will order on a rush today's, and the court reporter from yesterday knows as well. So E-Tran and full size, please.
Okay, thank you. And then I don't know, are you guys communicating with Royal about what day you need it, or did you want to tell me now?
Monday would be great if you can have it by Monday.
Monday, okay. Beginning of day or end of day? Do you know?
I would prefer beginning of day if that's at all possible, but I know with the weekend that might be difficult.
Okay.
Okay, thank you.
All right, have a good weekend. Thank you so much.